Hi, I'm Mary Jean Ziska. See from the driver's license. And I am doing a video today. The second part for the article that was located on the Florida bar. And I'll be doing that today. It's 11/24. It is the 14th of November, Saturday. It's a beautiful day outside. I got so much work to do. I'm going to be inside today. But I'm still at my father's house and we've got the windows all open. It's a beautiful day in Florida. But we're still trying to clean up all the mess that was created through fraudulent accounts, identity theft, abusive guardianships, and the second part of the article that I was going to read today, oops, excuse me, sorry, fell on the floor, is actually, it was written by Craig Harrison, and it's Protecting the Elderly from Financial Exploitation, The Dilemma and Solution, Part 1 and Part 2. They actually just had something on the news about a woman who they called it some kind of a sweetheart scam, which I think I had mentioned in one of my blog posts ages ago. Primarily, it was listed in the article as something that was a gypsy con scam or Irish traveler con scam. And this poor woman on the news had actually lost $185,000. She's an elderly woman who believed that someone actually loved her and was going to give her a ring. And he needed originally, I think he said he needed cell phones and then he needed laptops. And she sold her house to provide the finances. It's one other way that people actually prey on the trust of the elderly. They grew up in a generation where people didn't lie, cheat, and steal, that people were born and raised with an awareness and a consciousness of taking care of their neighbors, of being good to each other, of helping out. And I think some of those values and morals and ethics, unless you're around people who are raised that way, for me, it involves being around some amazing Christian individuals who have those ethics that you can still see. But the people that have lied, cheated, and stolen from me, from my family, are basically, I have to admit, growing up in Rostanor, Saudi Arabia, it was safe. So I have to include all the people that we met through Aramco, and Mother Aramco being able to protect us from any type of scams, and living in a gated community that where we were protected with the guards at the guard gate. We were protected from a lot of financial abuse. There weren't quite as many elderly there, but the people that I met, Rami Al-Naimi, Manur Al-Ashkar, different people who were from Saudi Arabia, were absolutely amazing individuals. The Ramcons that I met, I could never say enough about how generous and kind, how ethical and moral and upright. We didn't have to be worried about people stealing, people lying, cheating, and stealing from each other. It just, to me, what I remember, it never happened. I mean, it just didn't happen in our group of individuals, and it never happened. So if you surround yourself with great people, which is what I've been trying to do ever since this whole fiasco started. I'm still debating whether it started 1999 when I moved into my condo and was preyed upon by, I'd hate to say it was neighbors or individuals that decided a female living on her own with a business was opportunity to steal from me, which is horrible. But you know, predators, and just like they pick out children to prey on, or elderly to prey on, or disabled people to prey on, or anyone, it's definitely a mindset I'm not accustomed to, and I never ever want to have to actually be a part of. So anyway, the second part of his article actually delves into the, and here's the article, I'll place that, I hope you can see that. It's written, and it was actually submitted, and you can find it on the Florida Bar through the Florida Bar Journal. And it's the second part of the article is dealing a lot more with, because the article is called Protecting the Elderly from Financial Exploitation, the Dilemma and Solution, Part 2. Starts on page 48, and I'll read bits and pieces, maybe interject a few comments. However, this is something that everyone should be aware of, the financial exploitation. You hear about it, but if it's your grandmother, if it's your mother, if it's your father, if it's an aunt or an uncle, this can be devastating to their life, especially if they've worked their whole life and saved money, and then a criminal comes through and through either in the beginning of the article, if you see the first part of the video, or the other part 1, it was talking a lot about the financial exploitation and abuse through people manipulating and being able to coerce others into giving them monies and gifts, quote unquote, or to be able to sign paperwork where they didn't want to sign paperwork. So anyway, here's the article. It says, Craig starts out, there are remedies available to the person with diminished capacity who has been financially exploited. The problem is to convince the person to bring or consent to an action against the perpetrator, and to prove that a transfer of an asset to a perpetrator was not a gift to or compensation for services rendered by the perpetrator, or that an estate planning document is invalid. That's what I'm having a terrible time actually proving all of that through the fraudulent bankruptcies that were created using my name, my social security number, my address, all my information, done without my permission, done without me ever going to a meeting, taking any classes. I mentioned on one of the videos there are 10 violations of the bankruptcy code that created the Chapter 13, and then it was transferred over Chapter 7. No questions were asked because the word guardianship was actually involved, and that has to be changed. I'm hoping to go into the various changes in the laws that Senator Nancy, D-E-R-E-R-T, I believe is how her name is spelled, over in Venice. She's working on changing guardianship law, and there should definitely be changes. No one seems to know a clear distinction between limited guardianship, guardian ad litem, and guardianships. No one actually is acknowledging that rights are violated, and they're allowing criminal activity to occur. It's an actual felony, is what I was told, to create a bankruptcy using fraud. It was also a felony to steal Social Security money, put it into a bank account that was opened up using all my information at for a Fifth Third bank account that was completely and utterly created fraudulently, without my permission, without my consent, without me even meeting anyone. But anyway, let's get back to the article. He also goes into a couple different agencies. He mentions the role of the Department of Children and Family Services, and about an actual act. Let's see, I'll read it. The Florida legislature adopted the Florida Adult Protective Services Act to provide for the detection and correction of abuse, neglect, and exploitation of a vulnerable adult through both social services and criminal investigations. The Act established a program of protective services for all vulnerable adults in need of them, and it imposes mandatory reporting and requires immediate protective service investigations. The Act authorizes the Department of Children and Family Services to contact law enforcement for assistance if an individual is being prevented by a caregiver. The Act requires the department to notify law enforcement if there is a reason to believe that abuse, neglect, or exploitation has occurred. The Act provides the Department with complete access to all medical, social, and financial records of the vulnerable adult, authorizes and requires the Department to provide protective services or protective supervision to the vulnerable adult, and provides for emergency and non-emergency intervention. The term vulnerable adult is defined broadly to mean a person 18 years of age or older whose ability to perform the normal activities of daily living or to provide for his or her own care or protection is impaired due to a mental, emotional, sensory, long-term physical or developmental disability or dysfunction or brain damage, or the infirmities of aging. Nevertheless, the Department cannot provide protective services or supervision, even emergency protective services, to a vulnerable adult who does not consent to such services or supervision. That means there has to be a way that, I know in different even television shows, when someone's being held captive or and they're trying to notify someone that something's happened, there needs to be a way that these services can be enlisted, is what I'm thinking, and they need to be able to not have any penalties if someone actually requests the services. I think they're also worried that they're going to get in trouble with maybe the caregiver, if their caregiver is a family member or someone who's actually used their undue influence to retain finances or to steal from an elderly adult, or someone who's disabled, or even just someone with a title attached to their name, where someone is given power of attorney or guardian ad litem, litem ad guardiam. Again, my belief is that there needs to be more transparency within the entire system, and there needs to be more accountability. And there needs to be more people who are actually checking on the people who are supposed to be checking or taking care of different people. I'm sure there's many, many ways that these people are stolen from, whether it's stealing their food or their finances, their clothing, utilizing maybe their car, their home, or even just their contacts for their own personal gain. There has to be some type of accountability, especially if a caregiver. I think it would be so great, as far as like babysitting or even the elderly, you have a nanny cam, or you have some way of monitoring. You have a security system within a house. Of course, that's not available, and the cost would be quite a bit for every single individual. But you've seen different television programs where nannies may have hurt a child, and the parents would never have known because the child is too young. Same thing with a vulnerable adult or someone elderly. Perhaps they might forget, and be convinced that the bruises on their arms were actually caused by them falling instead of someone pulling or tugging them. But an actual video would definitely make sure that nothing was actually missed. So anyway, he also, through the article, goes into a definition of capacity, a legal capacity, and then he mentions, although the Act defines vulnerable adult broadly to include persons with diminished capacity who are subject to undue influence, the undue influence is a main topic of both Part 1 and Part 2. And that, I think, is hard to prove, and that sometimes perhaps is up to the discretion of the lawyers and judges involved. And if someone's being bullied, what do you say? How do you protect yourself? What can you do to protect your relatives or the elderly or disabled if this is going on? And how do you allow them to be able to point the finger at somebody who's either financially abusing them, like in this case, in this article, or the financial exploitation, or even verbal, or no type of abuse should actually occur. So there has to be a way to make sure that the laws coincide. They coincide with current events, like the current topics, and make sure that they're actually able to to actually enlist protective services of some sort, or protection of some sort. Without even it being an extreme case, there should be a form of there should be a way that someone can actually tell someone, hey, look, this is going on, or I think this is going on. You know, the CNA working for an elderly person just got a brand new Cadillac that she probably used someone else's name, or did this or did that. Who's going to know unless somebody actually reports it? And if that person bullied her way into getting the resources to get this car, or to do something, or even claims that it's for the individual, there has to be some kind of transparency where, and there has to be accountability. So anyway, if you have any ideas on how we could achieve that goal, I would love to hear them. You can contact me through Mary Jean Ziska at mysearchforjustice.com, www.mysearchforjustice.com. And let's see. We'll continue the article. What I put in my little notes over on the side, there needs to be changes in the legal system to assist when billing or threats of financial exploitation is evident. Okay, the article furthers the limited criminal prosecution for financial exploitation. The Florida Adult Service Act requires the department to orally notify law enforcement of alleged abuse, neglect, or exploitation of the vulnerable adult. Within 5 working days after the oral notification, the department must submit a written preliminary report to law enforcement. If it conducts its own investigation, law enforcement must submit its findings to the state attorney and the department within 5 working days after concluding the investigation. The state attorney must determine whether a prosecution is justified under the circumstances and report its finding to the department. And I put a big star over by criminal prosecution for financial exploitation are governed by Florida Statute 825.1031, Chapter 825 uses the term elderly person, not vulnerable adult, but the definitions are basically the same. Elderly person is defined as a person 60 years of age or older who is suffering from the infirmities of aging as manifested by advanced age or organic brain damage or other physical, mental, or emotional dysfunctioning to the extent that the ability of the person to provide adequately for the person's own care or protection is impaired. And then it says, later in the article, he mentions that proving the criminal exploitation of an elderly person is difficult, and many times the evidence is confusing at best. Florida Statute 825.1031 establishes 2 separate crimes for financial exploitation. Florida Statute 825.103b requires the state to prove that the assets of the elderly person were obtained when the perpetrator knew or should have known that the elderly person lacked the capacity to consent to the transaction. The statute defines lack of capacity no differently than the legal standard of capacity. I think that's a very valuable paragraph, and I'll read it again. Florida Statute 825.103 establishes 2 separate crimes for financial exploitation. Florida Statute 825.103b requires the state to prove that the assets of the elderly person was obtained when the perpetrator knew or should have known that the elderly person lacked the capacity to consent to the transaction. The statute defines lack of capacity no differently than the legal standard of capacity. Let's see if you can actually, that would be a better way I can do this so you can read it. And that's this right here. At least you're reading it. Then also, for the article furthers, let's see, the definition, he further says this definition is consistent with case law involving theft from a victim with diminished capacity. It is not shown when another gives property to another unless there was evidence that the defendant knew the victim lacked the mental capacity to consent to the taking of his or her property. If the elderly person has legal capacity, no crime can be committed under Florida Statute 825.1031B. Florida Statute 825.1031A does not require the finding of incapacity. However, the state has a high burden to prove financial exploitation pursuant to this provision. The state must prove the perpetrator knowingly, by deception or intimidation, obtained the assets of the elderly person. Intimidation is defined as the threat of physical injury or the deprivation of food, clothing, money, or other necessities. Deception is defined as the misrepresentation or concealment of a material fact relating to services, disposition, or use of property intended for the benefit of the elderly person. Let's see if I can actually have that highlighted. There's got to be a way to make this a little bit. I think that's a very, very, very important fact for his article. And I think it takes a great lawyer and someone who actually really fights for justice to make sure that this does not happen, and that they can prove that the exploitation occurred. And we need to make sure that there are more precedented cases protecting the elderly from the financial exploitation that can be done through intimidation, deception, and it has to be pretty clear. And it has to be pretty clear so that the elderly person or disabled person is able to retrieve the funds back. There has to be other legislation, I think, enlisted to make sure that the person who's supposed to be helping them, maybe it's a guardian, maybe it's a family member, maybe it's a neighbor, or just a caregiver of some sort, is not permitted to do any type of financial exploitation in any way, shape, or form. And there has to be, I believe there shouldn't be even a statute of limitations, that whenever the crimes are brought to the attention of the police, of the different services of the state attorney's office, that they should make sure that the criminals are prosecuted as criminals, instead of allowing them with a slap on the wrist to say, just don't do it again. Because obviously some people use the elderly, disabled, children, women, they think of these people as the vulnerable, and instead of helping, they actually hurt them. So let's see, I think those were some of his article. Then follows with, let's see, the court examined the statutory definitions of deception and intimidation and found no evidence. There was an article before that someone obtained her grandmother's money, that they didn't obtain their grandmother's money through intimidation or deceit. So I still think that, I don't know how you actually prove, but there has to be a way to make sure that someone isn't intimidated, doesn't have to sign paperwork, isn't lied about or cheated from or stolen from. Let's see, it further says, if the elderly person has the capacity to understand a transaction or make a gift, a successful prosecution for financial exploitation may prove difficult. Intimidation and deception may be factors in proving undue influence in civil cases, but these factors are necessary elements to prove criminal exploitation and pose a significant proof problem versus the Carpenter active procurement criteria to establish undue influence in a civil litigation or civil action. Then he actually follows that with limited civil remedies for financial exploitation. Florida Statute 415.1111 creates a civil action in favor of the vulnerable adult against a perpetrator for actual and punitive damages caused by the abuse, neglect, or exploitation of the vulnerable adult. The action can be brought by the vulnerable adult, his guardian, or personal representative. A person or organization acting on behalf of the vulnerable adult can also bring the action, but only with the consent of the vulnerable adult. So in this article, we're actually talking about criminal versus civil prosecution of these individuals. And he further states, therefore, if the vulnerable adult has a capacity, the only way an action can be brought against the perpetrator is if the vulnerable adult brings the action or consents to such action. If the vulnerable adult is under the undue influence of another, it is questionable as to whether the vulnerable adult would bring an action or consent to an action against the undue influencer or perpetrator. Let's see, the Florida Power of Attorney Act may create standing in third parties to challenge actions of an agent under a power of attorney. That's Florida Statute 709.21161 provides a court may construe or enforce a power of attorney, review the agent's conduct, terminate the agent's authority, remove the agent, and grant another appropriate relief. Florida Statute 709.21162 lists the persons and entities who may petition the court pursuant to this provision. Those listed include the principal, agent, successor agent, guardian, conservator, trustee, or other fiduciary of this principal, and the person authorized to make health care decisions for the principal, but only if the health care of the principal is affected by the actions of the agent. Also included are a governmental agency having the regulatory authority to protect the wealth of the principal and any other interested person if the person demonstrates to the court's satisfaction that a person is interested in the welfare of the principal and has a good faith belief that the court's intervention is necessary. And that is over here. Let's see if we can get that on here. It's talking about the limited civil remedies. And further down, also mention Florida statutes. You can print out a copy of his article, which is not only great reading material, a lot of amazing resource as far as trying to help to prevent the financial exploitation of the elderly. Further within the article, on page 5 of my printout, the Florida Rules of Civil Procedure do not necessarily require the consent of the vulnerable adult to file a proceeding. Florida Civil Proceeding, I think it is, 1.210A states, every action may be prosecuted in the name of a real party in interest, but a party expressly authorized by statute may sue in that person's own name without joining the party for whose benefit the action is brought. Florida Statute 709.2.116 and Rule 1.210 seem to permit an interested person or the Department of Children and Families to bring an action against the agent acting under the power of attorney. However, if the real party of interest, the vulnerable adult, objects to such a proceeding and the vulnerable adult's rights to sue and defend lawsuits has not been removed, can the authorized person proceed with the action. Even if the third party could proceed with the action, the vulnerable adult, by undue influence or otherwise, could undermine any proceeding as he or she has the authority to authorize or consent to any action of the agent or execute a release of the agent from liability. The agent would be subject to a criminal prosecution under Florida Statute 825.1031C. Then the role of the attorney. He mentions Genova, Genova. One of the cases he mentioned, I think that was in the first part of the article, in the part 1 of his writings, held that it is not the public policy of the state of Florida to protect an adult with diminished capacity from the undue influence of others. Nevertheless, Genova held that under the terms of the trust, Mrs. Genova established the means to protect herself from her own incompetence, which the courts can and should zealously protect her from her own mental incapacity. If a settler can protect himself or herself from incompetence, then a settler can protect himself or herself from undue influence in the same way. He further mentions he is an attorney that works with, I believe, with wills and trusts in the Sarasota area. And then he actually mentions creating an irrevocable trust. I think he was actually thinking of how you can prevent any of this from happening. and to create the legal paperwork ahead of time seems to be his best solution. I'm thinking to do something of that nature, but also to make sure that there's, again, more transparency within the guardianships or with working with elderly people, whether they're living in a nursing home, in their home, their caregivers, their family, and making sure that there are clear avenues that they can utilize to make sure financial exploitation can be reported without any harm to them, and it can be taken seriously. I think in America, a lot of times people have decided, whether you're disabled, you're elderly, if there's a label put on you, that a judge or lawyers, they don't want to touch it. They don't want to have to worry about it. I found through my experience trying to remove a bankruptcy, absolutely horrid experience. Nobody wants to touch it. Nobody is brave enough to actually stand up and say this was done fraudulently and somebody should be held accountable. The people who looked at the paperwork, the trustee department, both of the Chapter 13 and the Chapter 7 should be held accountable and should be actually made aware that these type of even in the Department of Justice, there's a whole article on how financial exploitation through bankruptcy occurs. Someone using their husband's name or someone using their child's name or being able to actually utilize information or hide assets or do different things. These are crimes that should not be allowed to be committed. And we need lawyers, judges, and anyone within with an authority figure to actually, well, first and foremost, it would be great if they were all honest and trustworthy and great individuals who, you know, fought for justice and righteousness with morals and values and ethics all combined. But in the case we can't find those individuals, they should at least follow the law. And Mr. Harrison actually mentions the irrevocable trust, creating an irrevocable trust to protect someone, whether they're being considered to be incompetent or elderly, or to protect their assets and different things. And then also a revocable trust. He goes through the difference of both of those. And then through the Florida Trust Code, other very interesting avenues of protecting oneself. If it's going to be yourself, you need to actually look into what needs to be done to protect yourself, your assets, your home, your finances. Have a clear will, I would imagine, and these can be done pretty early in life. It doesn't have to. You don't have to wait till you're 80 years old to actually have everything in place. You have to do preventative, and you actually, I think, laws still need to be changed. So, if you have any ideas on how these laws can be changed, how everything can be accomplished, please contact me. I am Mary Jean Ziska, and you can contact me through my website, www.mysearchforjustice.com. And I hope that together we can make changes that will improve people's lives, no matter how long someone lives, no matter if they're labeled disabled, incapacitated, not even incapacitated, or if they're mislabeled. We can actually make the system work. So anyway, take care. God bless. And have a great day. It is the 14th of November, 2015, and it's just about noon. Now, this video is just about 34 minutes long. So thank you for listening. Thank you for caring. And again, take care. God bless. And have a great day. Bye.